So almost 2 weeks into the Renters' Rights Act, and we are already seeing owners that could get caught out. Welcome to Maxine Lester TV. We keep landlords and property owners up to date with the legislation affecting the private rented sector. Our job in all of these videos is to point out pitfalls, explain what the rules actually mean in practice, and help protect you from getting it wrong, because renting property is no longer just about finding a resident and collecting the rent. There are over 200 pieces of legislation covering the private rented sector. And with the Renters' Rights Act now in force, the risks of getting something slightly wrong are hugely much greater. So it's our job to understand what those rules mean for you, your property, your residents, and more importantly, your future plans. So 2 weeks in, what are we seeing? Owners are getting caught out, not because they're bad, not because they're ignoring the rules, but because they've been given, I suppose, unclear advice, using old information, or they've made a perfectly logical decision that may not stand up if challenged later. So what do I mean by that? Well, the biggest issue that we're seeing is paperwork. The key date you need to understand is the 31st of May. By that date, all existing tenancies need to have been taken out of breach, and they need to be taken out of breach correctly. So firstly, if you've got an existing written tenancy agreement, you really don't need to issue a brand new agreement. And actually, this is one of the areas where we've been having a lot of calls. It's a lot of confusion over it. So what you need to do is, first of all, make sure that every single named resident on that tenancy agreement receives the official Renters' Rights Act information sheet. Now, we've seen some random leaflets, we've seen an old version, someone copied something from another website. The official government information sheet can only be got from the government website, and it must be served in the correct way. And this is where we're finding the second problem. Last couple of weeks, we've spoken to owners who thought they'd done the right thing because they emailed a link. Others have WhatsApped the information sheet over, and some have sent the wrong document. Some have not checked whether that every named resident has received it. They've just taken the details that they've had. And we've seen situations of even where the tenancy agreement itself says that the documents must be served by post, but the information leaflet has been emailed. Now, it doesn't really sound like a huge mistake. It sounds so logical. It sounds really sensible. It sounds like something any reasonable person might do. You've been asked to issue a leaflet and you've done it. But that's the point. The courts do not work on that seemed logical at the time. The courts will work on evidence, process, and compliance. And this is where the risk comes in. You're not going to notice the problem today. You're not going to notice it tomorrow. You might only discover it years down the line when you need to regain possession of that property. Maybe you want to sell. Maybe you want to move back in. Or perhaps there's been a serious breach by your tenant, so you've got to deal with it. So you serve the notice, but your resident doesn't leave at the point that they should have, and then you have to apply to the court. And at that point, that's when every document, every notice, every date, every method of service will be looked at. And if there's a gap, your resident may not need a complicated defence to stay at the property. They may simply say, the owner did not comply with the rules. So that could mean the notice is challenged, it could mean delay, it could mean you have to start again. And with the courts already under pressure, that delay could really completely disrupt your plans. So let me be really clear. This isn't about scaremongering. You'll always be able to regain possession of your property when you have a valid legal ground. But you've got to follow the correct process. The days of it'll be probably fine, are really over. The real question now is, can you prove that you did it properly? Because proof is going to be your protection. It's really not enough to say, well, I sent it. You need to be really confident what was sent, who it was sent to, when it was sent, how it was sent, and whether you have the evidence. So if there's 2 named residents on the tenancy, both need to be covered, even if you've got 1 email. If there are 4 residents named, all 4 need to be covered. Again, you need to find out the second email, or you need to post it to the ones that you haven't got details of. And if you've got a portfolio, it's something, please don't leave it until last minute. You've most probably got about 2 weeks to get things sorted out. So why not subscribe below and receive regular updates like this? We're here to help you.